right. So, Mr. Lindsay, thank you very much for accepting this interview. For us, it's such an honor to have you here with us. And just to put you in context, we are the Colombian Association of Competition Law. The association is a nonprofit organization whose purpose is to promote the discussion in Latin America and particularly in Colombia about competition law, including antitrust, unfair competition, merger control, and consumer protection. So for us, it is very important that a person with your experience and your knowledge participates in this type of discussion with the association. The idea is also to create a network of professionals. So thank you again for accepting the interview.
It's my pleasure, and I applaud your association for promoting competition. That's what I've devoted my career to do.
Thank you very much. Now we would like to introduce ourselves very quick. The guys who will be interviewing you are Carlos Esguerra, which is the director of the International Committee of the Colombian Association of Competition Law. Carlos is also a partner of a law firm called Abogados, which is a specialized law firm in different fields of the law, including antitrust, data protection, consumer protection, and economic regulation. This is a bit of information about Carlos. On the other hand, my name is Camilo Andrade. I am a practice co-chair of the area of antitrust, unfair competition, and consumer protection at a law firm called Olarte Moure, which is a firm specialized in intellectual property and competition. This is a bit of information about us.
It's a pleasure to be speaking with both of you.
Well, thank you very much. I just want to take a minute to thank you again for accepting the invitation. For the association and for the international committee, is very important to have people with your experience and your background talking and discussing these relevant matters with us. I think that's enough of the introduction. Thank you very much, and I'll yield the floor to Camilo, who will be leading the interview.
Thank you. So, well, let's start with the interview, Mr. Lindsay. You are a partner at Dorsey Whitney, which is a very prestigious law firm in the United States. So why don't you tell us more about your practice at Dorsey Whitney in the antitrust practice group of the firm?
And I will do exactly that, but let me just start with one other introductory comment, because it really has affected the way that I view the practice of competition law. I began my career after law school by clerking for Judge Richard Posner, who was one of the fathers of the law and economics movement. And working with a man like that, with such a keen intellect and a wonderful writing style, has been a substantial influence on my own career. But I then began at Dorsey Whitney immediately after that clerkship. I grew up as a lawyer in our firm's trial group, or litigation practice, and so that also affects the way I deal with antitrust laws. But about 10 years into my career, our firm, which has a substantial mergers and acquisitions practice, needed someone to join the team that would handle the antitrust aspects of those transactions. So I began in our trial group. About 10 years later, I branched out and I continued working in our trial group, but also worked on antitrust investigations in antitrust investigations in M&A transactions. Then about 10 years after that, a lateral partner joined our firm and brought with him a practice in cooperatives, which it's not a unique model. That is, it's not unique to the United States. You will find cooperatives in the UK and in Spain, I know. I'm not familiar with them in Colombia. And that's basically a different kind of business model. It is owned by its customers if it's a patron co-op, or it's owned by workers if it's a producer co-op. But in either event, you have competitors coming together, and that creates some potential antitrust issues. A few years after that, I was introduced to the world of standards development, and specifically the area of the intersection between competitors getting together to write a standard and patents, which can read on the standard. In other words, you wouldn't be able to implement the standard without infringing a what's called a standards essential patent. So I began counseling clients in that area as well, and I've worked on some litigation in that area. So that's an overview of my own practice at the Dorsey Whitney law firm.
Very interesting. Thank you so much. Mr. Lindsay, you are an expert in the design of successful distribution models. And we would like to know, in your opinion, which would be the main challenges, or which are the main challenges from the antitrust perspective to design a distribution model?
So before you get to the antitrust perspective, the first question in dealing with a client is always, what kind of approach to the market do they want if they're starting afresh, or if they already have a distribution model and they think that there's a problem, identifying what the business problem is. For example, I will often have new clients come to me and ask me to develop what is called a minimum advertised price policy in their distribution network. And that basically tells resellers of the product that they cannot advertise at a price below a certain minimum. They can sell at whatever price they want, but they just can't advertise low prices. Well, before you just say, sure, I'll draft that policy for you, you have to ask some questions. So one question would be, how many distributors do you have? Because the problem might be that you just have too many distributors competing with each other for business. And in that case, you really don't need, well, you may still want one, but you don't need a minimum advertised price program as such. What you need to do is address the fact that you have too many distributors. A different issue might be they have the wrong kind of distributors. So for example, if you're trying to sell your product as a luxury good, you need to think twice about selling to Walmart. There's nothing wrong with the Walmart business model. And there are companies that sell to them and also sell other products as luxury goods. But going in and asking Walmart to act contrary to its everyday low prices policy is just a non-starter. So sometimes the question is, are you selling to the right distributors? Then you get to a number of different questions. So for example, if they have too many distributors, you have to figure out, is it legal to terminate them? What do the contract provisions say? Is there is the company doing business in a state that has a dealer protective statute for that particular industry? So for example, automobile dealerships are protected in most states. There are, here in the Midwestern portion of the United States, you will find statutes protecting dealers in farm equipment or construction equipment. And those laws vary by state. So then you need to think through, how can I get to those terminations? Is there a legitimate way to do it? And then you get to the question of, all right, let's assume that a minimum advertised price policy is the right policy. What are you going to do to enforce it? How are you going to detect violations? Are you going to do that through a dedicated personnel in your own company, or are you going to rely upon an outside service? And there are plenty of them that will monitor advertising within your industry and let you know if someone is advertising below the minimum price. But understanding in practice how this policy will work, because these policies are not self-enforcing. Companies that are advertising below the prices at which you would like them to advertise aren't necessarily going to say, oh, this policy has been adopted, of course, I will instantly comply. So you need to think through, how will I detect violations? And then even more importantly, you need to understand what consequences a reseller's decision not to comply will have. And those will vary widely. I've drafted a lot of these policies, and they will typically have some consequences, such as we will suspend sales to you for 30 days for the first violation, 60 days for the second, 90 days for the third. But sometimes that's either too much time to suspend, sometimes it's too little. So it gets to be very industry specific. And the assumption that I haven't gotten to is the legality of these programs. Minimum advertised price policies are about, I would say, 99% legal. And by that, I mean, I can imagine some corner case where it is a part of a larger allegation of violations. So for example, in the early 2000s, in what was then the music compact disc industry, it was a highly concentrated industry, and a number of sellers of music discs adopted MAP policies, not exactly simultaneously, but close together. And the FTC challenged that and obtained some consent decrees. To note about that are, number one, that industry doesn't really exist anymore. I suppose there are still some, but for the most people, it's been replaced by
not because of the minimum price advertising restrictions, for sure.
Right, and the second is there haven't really been significant challenges to minimum price policies since then. Now, an exception might be the state of California, and that gets us into a different but related question about resale price maintenance, and I think we'll be discussing that in a few moments, so I'll defer those comments.
Yeah, well, actually, this has been awesome, because I was writing down the question that I wanted to go forward to you, like, how do you terminate those contracts? Because in Colombia, for instance, and I'm sure it's the same in the States, so as you already mentioned, we have some strict policies protecting dealerships. So terminating those contracts can be even riskier than even the antitrust allegation. But you already addressed that. Just to be clear about this, because the minimum price advertising is something that hasn't been developed in Colombia. I am not aware of any decision of the Colombian authority regarding that, but I can foresee for what we see here and previous decision, the authority is very strict on restricting any kind of liberty of the dealers to conduct their business after purchasing the products, whatever they want. So what is the rationale, or what was the argument put forward to distinguish that restriction for resale price maintenance or any other kind of restrictions? So the courts there said, okay, minimum price advertising is something that you can do in the light of antitrust law.
Well, the distinction is that a minimum advertised price policy, well, first of all, number one, it might just be a unilateral policy. And here in the United States, the Sherman Act prohibits agreements in restraint of trade, but it does not prohibit unilateral acts. And there's a long line of cases that says it's okay for a manufacturer to announce a policy in advance and then apply it when someone chooses not to comply with that policy. That dates back to the Colgate case in 1927. So that's a long established principle. So the second is, it is not an agreement on the actual selling price. And up until the 1990s, and then again in 2007, and I'll come back to that in a moment, agreements between a manufacturer and its resellers that set a minimum price at which the product could be sold, or even a maximum price at which it could be sold, were per se illegal, or you might call them hardcore violations. That law changed in the 1990s, in part due to a decision by Judge Posner, who questioned whether that really made sense for maximum resale price limitations. But since that's what the law was, he said we have to hold for the plaintiff. The Supreme Court took the case and said, Judge Posner, you were right to defer to us. You were also right that we need to change the law. So then in 2007, the US Supreme Court ruled that minimum resale price agreements would no longer be considered per se violations.
That's the Lindsay case, right?
The problem, though, here in the US is that we have not only federal law, but we also have the law of 50 states. And there are some states, California is the most notable, and Maryland would be the other most notable, disagree with the federal rule, and they say in those states, minimum resale price agreements are still illegal. So coming back to your question, the difference between a MAP or minimum advertised price policy and a resale price maintenance agreement is that the MAP policy does not affect the price at which the reseller can sell. It just prevents them from luring in customers with promises of low prices, and let's assume those promises are truthful, but it's also affecting the liberty of other resellers to charge higher prices if that's what they think is the appropriate price.
Okay, yeah, well, maybe it will be useful for our viewers later on to draw some distinctions here. Although, of course, the Colombian competition system is very much influenced by the United States, and of course by no one less than Richard Posner, of course. But there are so many differences here. You have two authorities there. We have only one. You have the federal system. We have a centralized system. And the wording of our law is based on the European model. So we have object and effect restrictions, while you have the per se and the rule of reason and the Greek look kind of in the middle. And one of the most notable differences is that we have, in my opinion, as far as I can tell and I have studied, Colombia has a broader scope of competition law in the world. That's my opinion, because we have a little like catch-all clause, a general clause. Then we have all the specific kinds of conduct that can be regarded anti-competitive in the way that is described in Europe. But we also have one real problematic article about unilateral conduct by non-dominant agents. So in this case, it will be very difficult to apply this MAP doctrine in Colombia because it could be, or it could fall into the scope of this unilateral conduct of influencing someone for not reducing their prices. There will be that discussion of if you're already affecting the price at which the product is sold or only the advertising. But yeah, it will be a really nice discussion to have here in Colombia, which haven't done advanced yet. So
well, but that gets us actually to a fundamental philosophical question. Whose benefit are the competition laws for? Yep. And here in the US, since at least the early 1970s, it was really settled that the laws existed for the benefit of consumers, the so-called consumer welfare standard. And that may mean that some competitors go out of business because they are not serving consumers as efficiently or as well as other competitors. I will say that here in the US, we are revisiting that and whether that should be the standard. For example, in the area of employment, there is for the last 4 years or so, so this started in the Biden administration and has been sustained started in the Trump administration and has been sustained in the Biden administration. There's been a significant focus on agreements between employers not to compete in the talent pool. No poaching agreements, they are called. Well, you could argue that keeping your employment costs down actually is to the advantage of consumers. So this sounds kind of like a producer welfare standard, the employees being the producers. But it's also a question of allocation, because presumably companies would bid up the price that they have to pay for employees, and that results in reallocation of employees to companies that can use them more effectively to the ultimate advantage of consumers. But I raise this because one of the questions that any jurisdiction should be asking is, am I trying to protect the liberty of competitors, or am I trying to protect the economic interests of consumers?
Yeah, well, here in Colombia, I used to work at the authority, so, and I'm really respectful of the authority, and I really admire them. But I don't think the authority has gone into that kind of philosophical debates in the depthness that should be. But what I will say that is that here they will follow the European standard, and they will be highly influenced by this new trend that you mentioned is happening in the US with all the new administration and these new advocates for the new Brazilian branch of antitrust. And I will say that definitely for Colombian purposes, the liberty and the freedom of the companies to conduct their business as they wish, it will be taken into account as an objective of the competition law for sure. But yeah, you're right. This is really philosophical, and this takes us back to the beginnings of antitrust in the world, not only in Colombia, but in the world, which happens to be in the US. So this is very, very interesting. So,
although even if you are interested in protecting companies' ability to do business as they wish, you are still favoring one group of companies, the resellers, letting them do business as they wish to the disadvantage of their suppliers.
I completely get it. I completely get it. And this is probably, and I don't know if Camilo agrees, but this is probably the most problematic part of competition law, is how to deal with distributors and how to try to protect your business. And the way to protect your business is also protecting the price at which your business and your goods are being resold, because the price says something about your brand also. And the price also can generate problems in the distribution chain. But so far, the superintendents here in Colombia, following again the lead of the European, are very strict on that, and there are like very, very few exceptions. This one of the minimum advertising price hasn't been analyzed, but I'm not really sure if it will fly. And yeah, but anyway, this is a really interesting point. On the other point that you mentioned, actually, you mentioned a really interesting argument about the no poaching agreements. And there is an investigation going on in Colombia for no poaching agreements. The authorities investigating some of the main football teams in Colombia for no poaching, for trying to restrict the football players to go to other teams. I'm not participating in that investigation, but some of the people that will see this interview are, and I think they will find the argument that you just explained very, very interesting, and probably very helpful for them.
Well, it's an old debate. I have taught antitrust law as an adjunct professor at 3 different law schools. And I think the last half dozen times I taught it, I supplied a group of readings from, when I taught it at a Roman Catholic law school, it was a selection of readings both from Catholic social teaching, but also from Jewish teaching. And there's some interesting observations in the Talmud about competition issues and whose interests ought you to be protecting. So it's and I raise this with my students because it's a fundamental question of values. What is the legislature trying to do? Because well, I'll give you an example. There was an announcement just today that the U.S. Department of Justice Antitrust Division and the National Labor Relations Board were going to be cooperating in labor matters. And the statement was that both the DOJ and the NLRB are trying to promote competition in the labor industry. Well, that's not entirely true, because the NLRB is also designed to help workers organize into unions. And when I explain to my students that one could think of unions as labor cartels, we have a set of values. And in fact, the antitrust laws back in the late 19th, early 20th century were being used to attack labor unions. We decided as a society that that was not what we wanted. We wanted workers to have the ability to organize. So we came up with the National Labor Relations Act in the 1930s, which specifically permitted workers to organize, even though when you think about it, it's a price-fixing cartel. It's one that we happen to think is a good idea.
Well, this is incredibly interesting, but I think we can discuss about it like 2 months in a row or many hours,
Yeah.
and I don't want to steal much more of your time. So neither Camilo's who had like a couple of other very interesting questions related to this. So Camilo, I think we can go on and move on to the second question.
All right. Well, Mr. Lindsay, it's very interesting your point of view and your explanation. Actually, I was going to make you this question at the end of the interview, but as we already spoke about minimum price advertised policy, I'm going to make this question now. In Colombia and in general in several Latin American countries, resale price maintenance is highly criticized. We understand that in the United States, resale price maintenance is not considered a practice that affects the market and consumers by itself. And we would like to know your opinion on this matter. So do you believe that US law plays an efficient role in preventing consumers from being affected by reselling price maintenance, or it is a fact that this kind of practice is not good for consumers and for the market?
Well, there's a saying, I think it's attributed to Thomas Sowell, who's an economist in this country. There are no solutions, there are only trade-offs. So when you think about resale price maintenance, one of the things that it is doing is permitting resellers to basically protect their margins, so that they will have a larger gross profit margin, and in return for that, they will be willing to promote a product. If they don't have that protection, they have less incentive to provide those pre-sale services, because they know that they provide those services and then someone walks down the street to a store that doesn't provide those services but is selling the same brand of product. That leaves open the question, how much value do those services provide? And the answer to that is, it depends upon the customer. Think about going into an electronics store. If you are highly informed about electronics already, because it's just an area you've studied and know things about, and you read the magazines and you figure out which are the best products, then what you're looking for is price and maybe some post-sale service. So those pre-sale services that the manufacturer is trying to incentivize the retailer to provide don't really have any value to that customer. In contrast, the less educated, less informed, less sophisticated customer goes into that same store. They want to be educated about the product. That is a real value that is being provided to them, and you have to somehow arrange for compensation for that real value. So that gets you to the question of, which of those two cases do you think is likelier to occur? And personally, I think that the second case is likelier than the first, but that first set will be disadvantaged because they're going to be paying a higher price in the product for a service that has no value to them. So that's the trade-off. And that's, when you think about that, that's only one of the rationales for resale price maintenance. There are others, and you could go through the same kind of analysis.
When I was doing my LLM, I got the honor and the privilege of being taught by Bill Kovacic. He was one of my professors there in the LLM. And when we were studying RPM, and also when I worked for a couple of months in the US, my take on that is that even after Legion and Colgate all these decisions that you already mentioned, and even if at the federal stage, the RPM should be assessed under the rule of reason, in practice, there are many states and very, very relevant states that have forbidden it by law, as I understand it. So what Mr. Kovacic told us is that in practice, authorization for say in some way of RPM in the United States is very, very difficult for companies, because if they want to do business, for example, in California, I believe, and in New York, I think, are those, you correct me if I'm wrong, are still prohibited by law. So that RPM freedom is kind of not real in real life. In practice, businesses still struggle with these prohibitions. Is that right?
Yes, but what I would say is that the state of the law is not quite as clear. The only place where it is crystal clear that an RPM agreement is illegal is Maryland, because after the 2007 decision in the Legion case, the Maryland legislature adopted a statute that said resale price maintenance agreements are illegal. California would be the next, because there's a long line of cases that interpret the statute as prohibiting resale pricing agreements. But it's, there is at least room to make an argument if you want to pay lawyers to make that argument for you and take all the legal risk that goes with it. New York and New Jersey are different. They have statutes that, although the state attorney general in New York really wanted them to be read as prohibiting resale price maintenance agreements, he lost that case. In those two states, the agreements are unenforceable, but not illegal.
Okay.
But to your broader question, yes, if you're a national company operating across all 50 states, you need to take into account the lowest common denominator. And you have to recognize that you may have to have what is, from your perspective, a suboptimal policy because you don't want to take risk in those states. Now, the answer to that is you don't do this as an agreement, you do it as a unilateral policy. The effect of the 2007 Supreme Court decision in Legion then is that it reduces the legal risk if you get it wrong. And let me explain what I mean by that. In Legion itself, the manufacturer's policy started out as a unilateral policy. But then as time went on, there were more and more facts that made it look like an agreement with its retailers rather than a unilateral policy. And ultimately, that's where a fact finder decided it had landed. It was an agreement. And so that went up to the appellate courts based on the assumption that you had an agreement as to resale price. If you had only a policy, even in California, that's not an agreement in restraint of trade. You will have a state enforcement official who will be more aggressive on deciding what facts might constitute an agreement rather than a policy, but you still need to have it be an agreement.
Okay, that's very, very clear. Thank you. Camilo?
Yes. Well, Mr. Lindsay, nowadays the authorities around the world have brought the discussion about dual distribution. And this has become a very controversial topic. When we talk about the big four or the giants, dual distribution is something that calls our attention as consumers, but also and mainly as legal advisors of companies. So we would like to focus on this topic, and we would like you to tell us, in your opinion, how do you think dual distribution impacts the design of a distribution model?
Well, it is certainly one valid approach to distribution. There are a lot of companies that will both sell directly to end customers, but also sell to distributors who will sell to end customers. A common example would be a company that sells through the big box retailers, but also has a company website at which you could buy the same product. So without additional facts, you would think, what's the problem? It's just more ways to reach consumers. What's the issue? Well, there are in fact a number of issues. So let's set aside for the moment any of the big tech companies and just bring it down to examples that are more common. If I am a reseller of a company's product and that company is engaged in dual distribution, first question I'm going to ask is, where are you doing that? For example, you could see a company that's engaged in dual distribution that has divided the country into 17 territories, and it has kept 5 of those for itself and assigned the other 12 to others. Within those geographic territories, each reseller has an exclusive, and the company has that same kind of exclusive in the territories that it has reserved for itself. And I should add that the law is very clear that except in extremely unusual circumstances, it is legal in this country to assign a territory to a reseller and tell them, I won't let anyone else sell into your territory and you won't sell outside your territory. I know the law is different in some other jurisdictions. I'm not sure about Colombia, but that would be one thing that in the US legal setting I would be asking. And there are all sorts of flavors of that. It might be that the manufacturer also reserves certain national accounts for itself, so it can sell to those accounts even if they're in what it would otherwise be an exclusive territory for a distributor. So that's the first question. How much am I getting? How much internal intra-brand competition within the same brand am I going to be facing? Then I'm going to ask some other questions. What happens with the information that I give you? You're going to know something about my ordering. If I have warranty registrations, you're going to know something about my end customers. If I'm the independent reseller, I want to know that you're not going to abuse that information and start stealing customers from me. I'm also going to want to know what's your policy toward pricing. I don't want to see myself undercut by the prices that the company's own direct distribution arm is selling. Now that's really challenging because although legally the corporation is a single person, in the real world you have divisions of a company fighting with each other, and the retail division will try to get lower prices from the wholesale division. The wholesale division will try not to give those, and the retail division gets to decide how much margin it wants. So it might decide to take a thinner margin than an independent reseller would like to see. So you have that kind of issue. So that's how, generally I would think about it. In and of itself, dual distribution isn't really an antitrust problem. It's a contract problem.
Do you know if any kind of guidance, like and counseling points on how to deal with that information problem that you mentioned, which I believe is the main problem, and I completely agree with you. Dual distribution is a perfectly legal and even desirable, in my opinion, mode of conducting business. I do recognize the problem of the information. How are you going to use the information of the sales of your distributors and how not to abuse that information? Is there any kind of guidance issued by the authorities or any kind of relevant case that you say this is something that you can look at to advise your clients on how to deal with that information in order to avoid abusing it and using it in a wrong way in the light of antitrust?
There are cases, but the first question is always going to be in any commercial relationship, look at the contract. You know, does the contract have a relevant provision? And if you are the independent reseller entering into a contract, that's something you want to make sure, or if you're more precisely, if you are the lawyer for that independent reseller, that's something you want to pay attention to and get as favorable a provision as you can. And you might, for example, contractually require that the manufacturer maintain ethical walls, have a contractual obligation not to share wholesale division's information with retail division. Maybe even require you can go even further by having them store the data on a separate server, and the retail division has no access to it. But if you get to that level of detail, it's going to be a pretty prolonged negotiation, and the manufacturer might decide you're going to be trouble in the future. I don't want to deal with you. So you have to take a realistic approach in negotiating that kind of provision. Once you've negotiated it, that's the first place you're going to look. The second place you are going to look is to the state statutes that protect dealers. Now, I don't recall one off the top that specifically addresses this issue, but it might be something where there would be a state law provision, and again, by state, I mean one of the 50 states, that could protect an independent reseller in those circumstances. That would be something you'd need to look at the specific state law for.
Well, this is great. This is great. Thank you very much. I'm not sure if we have any more questions, but we don't. I know how busy you are, and we don't want to steal more of your time. So probably it's time to wrap up.
That's right. We don't have more questions. Mr. Lindsay, thank you so much for this interview and for your time. We believe this is very constructive for the Colombian Association of Competition Law. So we do appreciate your time and willingness, and we hope to have you here in another occasion. Thank you very much.
Thank you. I was happy to do it, and I appreciated your excellent beginning questions as well as your follow-up. So thank you very much.
Thank you.